Good evening, everybody. Welcome to Law&Crime's Daily Debrief. The state of Connecticut has officially refused to prosecute the murder case it filed against wealthy defendant Fotis Dulos. Prosecutors null-prossed the case or refused to move forward with the charges against the man who committed suicide not long after he was accused of killing his wife, Jennifer. Today, Fotis Dulos' attorney, Norm Pattis, did not let the state drop the case quietly.
I guess it shouldn't be a surprise, Your Honor. Mr. Dulos is deceased. As a result of that, the state is entering a nolle in these three matters.
And Judge, on behalf of Mr. Dulos, Attorney Smith and I object, and we object for the following grounds. There are two sets of competing interests at a criminal trial. The state obviously has its interest in specific and general deterrence, in rehabilitation, in punishment, and in protection of society. But counterbalanced against those is a defendant's reputation plus interest, a right recognized by such cases as Wisconsin v. Roth under the 14th Amendment. And on behalf of Mr. Dulos, who manifestly and steadfastly maintained his innocence, and on behalf of his estate and his memory, we want to vindicate that interest, and we would like to go to trial.
From there, defense attorney Norm Pattis gave a glimpse of his current theory of what happened to Jennifer Dulos.
We understand the circumstantial nature of the state's case, but we find certain elements of the state's proof to be shocking. For example, the second warrant filled with law enforcement beliefs about Mr. Dulos in a red truck. There is no evidence that he was ever in that truck. Indeed, we don't believe he was. As recently as 2 months ago, we've received reports of sightings of Ms. Dulos. We have no credible evidence to suggest she's alive, but we can't be faulted for pursuing every lead. If the case did go to trial, Judge, we would have proceeded under the theory, and we have reason to believe that this theory is in fact true, that Ms. Dulos came to a violent end at the hands of third parties unrelated to Mr. Dulos. That as to his disposal of certain items, in the Hartford area in the day of her disappearance, he left his home at one point in that evening and saw a third party known to the participants in this trial standing near a pile of debris in his yard, and he panicked and disposed of that debris. While he may have had suspicions about what that debris was, he did not, in fact, knowingly dispose of items that were associated with a pending investigation.
And that line in court was the bombshell. From there, the prosecutor presumably got tired of listening to this theory. The prosecutor tried to cut Pattis off, but Pattis continued by saying Dulos was the victim of an immense conspiracy and promised a lawsuit against the state by the Dulos estate.
Judge, I want to not turn Pattis off, but cut him off. I believe he's objecting to the nolle, so in light of that, I'm going to move to dismiss the matter.
I'm entitled to make my record as to the basis of the objection, and I'm doing so for purposes of appellate review.
Mr. Pattis, could you finish up, please?
Yes, sir. So we don't believe there is, while we believe that there may have been probable cause to initiate an investigation of Mr. Dulos and to bring the charges, there really is no question in my mind that had the case been tried, he would be acquitted. His suicide note made it clear we were in possession of evidence. We've reflected some of it here, not all of it. We're going to ask the state for permission to bring an action against the state under the Claims Commission for its transformation of warrants in this case into the functional equivalent of what our law does not recognize, that is an investigative grand jury. And it is our hope that we will someday, somewhere, get a fact finder to listen to all the facts, all the evidence in this case, because when it happens, they will conclude that Mr. Dulos was not only not guilty of a crime, but was himself the victim of a conspiracy so immense that in the end it drove him to despair and to take his own life. So for those reasons, we object to the nolle.
Outside court, Norm Pattis promised to appeal both the state's gag order, which was lifted today, and the dismissal of the case, and he answered my questions about whether he was afraid to name the killer outside of a court hearing out of fear he could be sued for defamation.
Had the case gone to trial, the conduct of his lawyer in giving a phone up, asking for it back, and the police not returning it tells us everything we needed to know. The police were less interested in truth at that point than in developing a suspect. They effectively stole his phone when he asked for it back. They said, we're not giving it back. We would have had plenty to say about that at trial. As to what he did or didn't do that day, great question. I wasn't there, I don't know. I don't know that it's explained. Anything in the home is explained by the bags. There were some trace elements found in the home. To date, the state has not disclosed to us any of that that discovery from items found in the house, so I can't evaluate what the state never showed me. If Ms. Dulos is in fact dead, we have reason to believe she met her end at the hand of third parties unrelated to Mr. Dulos and without his knowledge. Obviously, we were working on development of that evidence to present at trial in September. There will be no trial. We won't say anything further about that. As to the bags and the disposition of items on Farmington Avenue, we've said all we intend to say about that. We've said it in open court. I'm not worried about a defamation claim. I'd challenge anybody bringing an action against me to take his or her chances in front of a jury and recite that. Mr. Dulos' death caught us both by surprise, and it's something from which you don't quickly recover. We didn't see it coming, and we cared deeply for him. And Mr. Smith and I have some healing to do. I mean, I'm not expecting sympathy, but it takes time to recover from the loss of someone you care about.
4 attorneys are with us tonight. Let's begin with Dina Dahl and Gigi Gonzalez on this case. So Dina, now Norm Pattis is saying Jennifer Dulos was probably killed and that his now dead client disposed of evidence. He was saying Jennifer Dulos was still alive at what point? So what is it?
You know, it just sounds like a lot of posturing to me, really. It was the right thing to do to dismiss this case. And, you know, in his suicide note, he really alluded to this public opinion really bothering the former defendant. And his lawyer, I think, is just trying to clear his name, but this is not the right venue. If they actually bring a case, a wrongful prosecution case, all of that can come out.
Yeah, I mean, I'm really curious to see exactly how that's going to go because there's all this other litigation swirling in the background of these criminal cases. So, Gigi Gonzalez, Norm Pattis did not reveal who he thinks killed Jennifer Dulos, and the press wanted to know if he would ever name names. He challenged anyone to bring it on when I asked him about the defamation angle here. In other words, you know, can you go out on the streets, Norm Pattis, and start naming names? And could you get in trouble for that? Because now he does not have a legally privileged venue to name names. Can he ever name names, in your opinion?
Well, you know what? He could if he wanted to. And the truth is a defense to defamation. So whoever he names better be sure that they're not the ones who did it. Otherwise, they're going to have to say in a court of law that they didn't do it. And this attorney is going to prove to them that they actually did in order to defend his statements in a court of law. And it's going to definitely cause problems to anyone who's accusing him of defaming their name.
Yeah, you know, I mean, I sense that this will just continue rolling along. And of course, we will continue watching it. The cases against the other 2 defendants are still on the docket. This case just dismissed the case against Fotis Dulos. So let's move on now. We are learning a lot more tonight about jury deliberations in the trial of now convicted rapist Harvey Weinstein. The New York Times late yesterday published anonymous interviews with 3 of Weinstein's jurors. They listed several reasons why they did not convict Weinstein on accusations that Weinstein had raped actress Annabella Sciorra. First, Sciorra's account was 27 years old. Second, Sciorra admitted she had been addicted to Valium. Third, Sciorra was an established actress when she said Weinstein raped her. The jurors said that did not match the pattern of Weinstein's other attacks. Weinstein's other accusers were young women trying to break into the industry, and Weinstein lured them with the promises of work. Speaking of Weinstein, one juror told the paper, even if he is convinced of his own innocence, he's got to regret the choices that he made. If not, then he is a monster. Our other guests are with us tonight. Adam Conta and Jessica Morak are here. So, Jessica, we had jurors saying Weinstein harmed himself by not taking the stand and by putting this friend on the stand who basically testified that Weinstein had an insatiable appetite for women of all things. The jurors said that just did not work, Harvey Weinstein. That seems reasonable, right?
Especially in a case where you have a predatory sex assault on the indictment, right? And so part of the Molyneux, in this case, the hearing before the trial, which allowed the other accusers to testify, was to talk about this motive, intent, and sort of common scheme and pattern that Weinstein perpetrated through the Hollywood industry. So when you have that as your theme of the case, a witness who's saying that you have an insatiable appetite for women is not going to help you deflect that.
Yeah, exactly. I agreed with that as well. And we were asking questions about that during the trial, I think, Adam. So are the jurors' reasons for discounting Annabella Sciorra legitimate in your opinion, Adam?
I mean, they're the reasons. And to me, no. but only because if you compare it to the testimony of Mimi Halle and Jessica Mann, I thought that Annabella Sciorra's testimony was the most compelling. I mean, as you just asked Jessica, sure, they didn't put on Harvey Weinstein. They didn't put on any close friends to vouch for him. They didn't put on his brother. So he was left standing alone with Donna Rotuno and Damon Sharonis saying that he was innocent without any corroboration. But I'm still shocked that they didn't give more credit to Annabella Sciorra's testimony.
And Jessica, very briefly here, the fear, if you're the defense, is that what the jurors said indicated that they were holding it against Harvey Weinstein for not taking the stand. He doesn't have a duty to take the stand. It's the state's case.
Absolutely, and they would have been instructed about that in jury selection, as well as the fact during jury instructions that this cannot be held against the defendant, and you cannot speculate as to why the defendant did not testify on his own behalf. So that would have been repeated during jury selection and at the end before a verdict.
Certainly, and the jurors basically credited the testimony they credited. They seem to have independent reasons for those verdicts. The husband of the Los Angeles County District Attorney is facing online criticism over an incident with a Black Lives Matter activist. Cal State professor Melina Abdullah tweeted out video which purports to show the DA's husband pointing a gun at herself and others who showed up at the prosecutor's home. The protesters are unhappy about the DA's handling of a number of cases. The DA promised a meeting but never delivered, the group said, so they took matters to her doorstep with this result.
Good morning.
Get off of my porch. I will shoot you. Get off of my porch.
Can you tell Jackie Lacey that we're here?
I don't care who you are. Get off of my porch right now.
The DA, Jackie Lacey, said her husband did not know what was happening and that he, quote, meant no one any harm. An attorney who works with supporters of the Black Lives Matter movement told Law&Crime earlier today this confrontation was a long time in coming.
For 2 years, this same group of activists has gathered every Wednesday in front of the DA's office in Los Angeles to protest what they see as Jackie Lacey's lack of response to official misconduct. What they see is an office that refuses to prosecute police officers or even enact something as simple as a do not call list, saying, you know what, we're going to step back from relying on those bad cops in our prosecutions and in our cases. So far, they've encountered a refusal to meet with them, a refusal to engage with them meaningfully, and so they started staging protests and prayer groups in front of Jackie Lacey's home. They'd been there before. This was not the first time they'd been to her home, but on this particular morning, the day before the election in which Jackie Lacey is fighting for her seat, 2 of the protesters went up onto the porch to ring the doorbell, and then you saw what happened next.
The Idaho mother accused of deserting her children and failing to otherwise support them is due back in the continental United States. Mother Lori Vallow is due to face the charges in Idaho on Friday in court. She's due to be transported starting tomorrow. Vallow's 2 children, Tylee Ryan and Joshua Vallow, remain missing. Still ahead tonight, an update on jury selection in the murder case against real estate heir Robert Durst, plus a verdict in the trial of a Wisconsin father accused of shooting his own son in the head. Twelve jurors have been seated in the murder trial of real estate heir Robert Durst. Law&Crime's Kathy Russin reports that 12 alternates are slowly also being seated. Prosecutors say Durst killed his friend Susan Berman because Berman knew Durst had killed his wife, Kathy, years earlier. We will bring you opening statements as soon as they happen in that California case. A verdict in the case of a Wisconsin father accused of shooting and killing his own son. 44-year-old Kayle Fleischauer has been tried a second time for second-degree reckless homicide. 19-year-old Chase died from a gunshot wound to the head. Prosecutors blame the father, but the father said Chase accidentally shot himself. Testimony revealed the defendant's blood alcohol level when the shot rang out was between .293 and .440. The son's measured .278. The jury in the first case started conducting experiments to test the state's evidence, specifically why the pistol wound up so far away from Chase Fleischauer's body. The jury can't do that, of course. It's the state's burden, and that's why the case was tried a second time. During closing arguments, the prosecution said the night started off as a happy time for the family. It grew later, and things became violent.
Sometime between 1:30 and 4 o'clock in the morning, There was no wrestling match. It was a fight. Summer kept hearing all the noises and loud noises upstairs and heard, "I'll never hit my father." And this man has no injuries, to show that Chase was as good as his word. But Chase was beaten and bloody. Nearly every part of his body was injured. Contusions and abrasions and lacerations to his lips, injuries to his hand, which Dr. Mills testified occurred before the shot, bruises and scrapes on his right forearm and on his right foot, on his chest, and on his elbow. And you can see the linear skull fracture that both doctors agreed happened before the gunshot. It goes nowhere near the gunshot. Just like the windshield on your car. If you have a break and a crack in the windshield and the crack starts to radiate out through the windshield, if there's some other obstruction or some other crack in the windshield, that's where it's going to stop. And that's how that fracture was there, and how we know that fracture was there before Chase was shot.
Prosecutors said the defendant's conduct was criminally reckless because he brought a gun to a fist fight. The defense accused the defendant's daughter, the victim's sister, of lying on the witness stand, and then the defense laid out a so-called reasonable explanation for how Chase could have shot himself.
He goes over, and we know he sat on the stool. We've heard that from Stalky. We know that, and he's on the stool. He's drunk, as Dr. Arden said. He's a young 19-year-old drunk with a gun, a loaded gun. And he doesn't realize it's loaded because he had ejected a shell. So he's looking at the gun and it went off. Ladies and gentlemen, that's a reasonable explanation of what happened here, based on the circumstantial evidence. The circumstantial evidence is such, 3 to 6 inches, it went off. And what else do we have? We have his gunshot residue on his left hand and his right hand. We have DNA on the pistol, and we have a 3 to 6 inch separation between the gun and there. How do they disprove that? They don't. They talks about a reasonable hypothesis, a reasonable explanation. That is a reasonable explanation. Particularly, like Dr. Arden said, when you're sitting on a stool and you're drunk and you have a gun, and obviously he had ejected a shell. No other reason for anybody else to eject the shell. And at the same time, there's no evidence whatsoever that my client ever touched that gun that night.
The state then delivered a rebuttal, which the defense met with many objections.
There's no blood in the bed. There's no nothing in the bed. That's it. That's the bed.
There was never any investigation of the blood in it.
Sustained. Mr. Kaiser, again, relate it to the facts, please.
The underlying premise that Chase at .278, after he's been beaten and stumbling and drunk, suddenly decided to reach on top of the refrigerator for this pistol is simply not there. The pistol isn't seen. The blood-soaked sock feet are not seen. There's no blood on the refrigerator. There's no blood in front of it.
He's arguing the same stuff he did before.
Mr. Gray, Mr. Kaiser, you have 1 minute, and don't talk faster.
What Dr. Dunn said was, alcohol changes inhibitions, resulting in people doing more of what they were inclined to do anyway. Who was inclined to grab a gun? Not Chase. His friend told him they never talked about guns. They didn't have anything to do with guns. No, he never knew of Chase to be involved in guns. But who is? Who has guns? The defendant. This person, Kayle Fleischauer, he has guns. What was Chase inclined to do? Be a fun, wonderful person, athletic, who is outgoing, excited about...
Again, Your Honor, this is not...
Mr. Gray, please be seated.
Ladies and gentlemen, Chase Fleischauer's death came from this man, from this defendant. And that is why you should convict him of second-degree reckless homicide.
We got rocky there. After 3 hours of deliberation, the jury returned with this verdict.
The verdict has been returned, reads as follows. We, the jury, duly impaneled, as and for our verdict in the above captioned matter, find Kayle Allen Fleischauer guilty of second-degree reckless homicide, contrary to Section 940.06 Wisconsin statutes, as charged in the information, dated this 3rd day of March 2020.
Let's head to our panel of attorneys one last time this evening. Gigi Gonzalez, this verdict seems to me to point to the jury's belief in the sister who basically trashed the defendant, the father, and was not, I should say, based on the DNA or the gunshot residue.
Absolutely. She was the only other person in the house when this incident happened. So they're going to place a lot of emphasis on her testimony. And it is shocking that they didn't look at the evidence. You know, the defendant in this case didn't have gunshot residue on himself. He didn't really have the victim's blood on him. You know, the gunshot residue was all found on the victim, which is, indicative of a self-inflicted gunshot wound.
And Dina, so many questions about why the weapon wound up so far away from the victim's body. Perhaps those questions didn't necessarily need to be answered, though the defense spent a lot of time on them.
That was exactly what I was thinking. That was the hole in the first case. We know the jury really cared about that. And the defense expert they put on this time was not that strong. So it's possible they had the same hole again. Why would the gun have been so far away? And they could have put a lot of weight to that.
Exactly. I appreciate the insight there, Gigi and Dina. Let's turn to our in-house panel, Adam Conta and Jessica Morak. So Jessica, again, I'm going back to the belief of who's on the stand and the disbelief of all the experiments about the gun falling and then hitting a table and then bouncing onto the floor. Apparently that didn't really swing this jury.
It could have been a combination of both, though. So I found the sister's testimony was incredibly compelling. We heard her testify, and clearly the jury found her credible. But there were issues with the experiment, the demonstrative evidence that the defense presented. There was a lot of issues and how it was not analogous to what was going on in the house. The level of the counter was not the same. There was a bent elbow of the robot, which had never been introduced as a fact in the trial. This is a robot and not a human. And so I think that there was not enough evidence on the experiment, and there was enough for the jury to convict.
They rested on the testimony. Adam, quickly, did you like the verdict? Agree with it?
No, I didn't agree with it, and I think everything we're talking about didn't matter here because the jury only took 3 hours. I think they were drunk, and they decided that was reckless enough, and they found him guilty because of that.
And that could have been the way it went, and then we will watch an appeal, I'm sure. Appreciate the insight from the panelists tonight. Thank you for joining us. We'll be back tomorrow at 5 o'clock with our recap of the day in court.